There are some great marketing campaigns in our lifetime. 1, do you want fries with that? 2, don't you want to do the best for a loved one? And 3, everyone needs a will. Now, if you ask an attorney, that's not a marketing plan, but in reality, it is a marketing plan to get people to come see an attorney to talk about planning. Now, the reality is, what they're talking about there is a last will. If you watched the video about living wills, I talk about the fact that the law does a great job of confusing things. We have 2 essential documents, or 2 documents that we talk about in the planning process that use the term will. One's a last will, we'll go into details here, and the other is the living will that we talk about in the other video. They have nothing to do with each other. They're not interchangeable. The number of times I hear them used interchangeably is baffling to me. But I'm going to try to help you stop from doing that, or not put yourself in the position of doing that. A last will, at its base level, is your instructions to the court if you go through probate. My position is I don't want anybody to go through probate. So let's try to avoid probate altogether. That's part of planning. It's getting out in front of it. But part of a plan may include a last will, just to make sure we provide cover for a complete plan end to end. So if you're going through probate, that means you have to go to court to settle your affairs. It's better to have a will in those circumstances, because you're going to fill in some blanks. The court's going to have a procedure they're going to follow, and they have some default things that fill the question of who's going to be in charge, our personal representative. Sometimes you've heard the term executor. We only have an executor if we have a will. So if we have a will, we're going to nominate an executor. The other thing our will would tell us, our last will would tell us, is where ultimately do we want our property to be distributed. What a lot of people don't understand is the court has a whole list of people who are going to get paid first. It could be the government, it could be attorneys, it could be the court, it could be secured creditors, unsecured creditors, all the way down the list. And then there's heirs. And then if you have specific heirs, like I have this car that I want to go to this person, or I want $10,000 to go to this person, those people are higher up. And then you have everybody else that's going to split what remains in percentages. So your last will is your instructions to the court to fill those gaps and provide some smooth, maybe smoother, quicker process of getting those people and things in place. It is not the only thing you need to do for a plan. A lot of people think, well, if I have a will in place, that's all I need. A lot of people will call me and they'll start the conversation, I need a will. And I'll let that go. When I first started in law, I'd say, well, are you sure? And that would confuse people too much to continue on. So now what we say is, we'll talk about those things, and we'll talk about other things that you might need, but we'll see if a will is a necessary part of your plan. So understand, A, last will and living will, 2 completely different items. Last will, really the primary purpose of it is to provide instruction to the court if you go through probate. We'll talk more about avoiding probate and what probate is in another video. But it is something that you should consider as part of your overall plan. It's not the end-all be-all, it's a part of your overall life plan. Be happy to help you. I don't charge for an initial consultation. If you just want to have some questions answered to understand what your options might be, give us a call, 219-230-3600, and you can also visit our website, ccskaw.com.